I'm Harry Rock, and welcome to another edition of the Westfield Council on Aging Presents. This is a special collaborative effort between Mike Squindo, Executive Director of the Westfield Senior Center, Tina Gorman, COA Special Projects Coordinator, and Pete Coles, producer of WCPC Westfield Cable Channel 15. Our topic today is A View from the Bench with the Massachusetts judicial system and an overview of the Massachusetts court system. And my guest is the Honorable Mark Mason, who is just recently retired, who served 9 years as an Associate Justice for the Massachusetts Superior Court. We're going to be discussing the work of the Massachusetts Judicial Branch and the roles of the various courts. So welcome to the show, Judge Mason. We are thrilled to have you on, and thank you so much for making the time to share your expertise of what your life has been like, but most importantly, what the entire judicial system looks like within the state of Massachusetts.
Oh, good morning, Harry, and thank you very much for inviting me. I'm here actually on behalf of the trial court as part of our Public Outreach Month, and I want to not only thank you, but also thank the Westfield Council on the Aging for giving us an opportunity to come and talk about our court system here in Massachusetts.
And, you know, we've had a chance to talk a little bit off air to get to know each other, and I have to tell you, I am highly impressed with who's sitting across the table from me here. Your resume is just incredible. How lengthy it is, how much stuff you have done through your life, and you're still a very young individual. You retired early. You didn't even go till age 70, which is when you have to age out, but you retired much earlier than that. But when I look at your accomplishments, it's really, really impressive. So which courts have you served in, and just give our viewers a little bit of an idea of what your experience has been?
Sure. First, thank you very much. You flatter me. It's undeserved. You know, everything I have done in my life has just been a labor of love.
Right.
I was born with a passion for justice.
Wow. So you knew right early on.
Very early on.
Wow.
That I had this this direction toward what I now understand we refer to as the rule of law. Ensuring fairness and equality for everyone. And that's something that has driven me throughout my career. But as you say, I did recently retire, and I put that word in quotation marks.
Yeah, because you're not retired.
Hardly.
Right.
Those who know me know well that I am incapable truly of sitting still. So I retired from the Superior Court, serving here in Western Massachusetts, where I served for 9 years. And before that, I was a judge in the district court, principally sitting in Springfield, but also sitting in Points West, including here in Westfield. So I was a judge for 15 years, and in what was the perhaps one of the shortest retirements on record of one weekend, opened up my mediation and arbitration practice, Mason Mediation, just at the very beginning of January 2024.
Wow. So, yeah, you're definitely busy, that's for sure. And I love the fact that we aren't retired. We're just moving on to other chapters in our life, and those chapters keep on going. So let's talk a little bit about, I can't think of a better person to give us an overview of just how the judiciary is organized here in Massachusetts. So how many members serve on the Superior Court?
The Superior Court, which is the court where I last served, there are approximately 82 judges.
82?
That's correct. The Superior Court is a statewide court. Technically, we are not assigned to any particular region, although, in fact, that is how it has grown to be. And so we have 13 Superior Courts sitting in the 13 county seats. So here in Western Massachusetts, in Greenfield, in Northampton, in Pittsfield, and in Springfield. But in response to your broader question as to how the courts are organized, that's a great question because a lot of people aren't familiar with courts in Massachusetts. So we have fundamentally trial courts, which, as the name might suggest, try cases. And then we have appellate courts. Those are courts that hear appeals. And there are 7 departments, as we say, of the trial court. We have the district court and its companion, the Boston Municipal Court. We have the Superior Court, where I last served, the Probate and Family court, the housing court, the juvenile court, and the land court. Those are the trial courts. Then we have what's called an intermediate court of appeal, which is aptly called the appeals court. And then we have the ultimate court of appeal in Massachusetts, which is the Supreme Judicial Court. And fun fact here, the Supreme Judicial Court and its predecessor is the oldest court in the United States. And
is it really?
Absolutely. And the Superior Court is the oldest trial court in the United States at just about 165 years young. And together with all the other departments of the trial court, the appeals court, and the SJC, we here in Massachusetts serve under the longest continuously enforced constitution in the world.
Wow.
And so a lot of people don't know that, but that's really proud heritage.
That really is.
Yeah.
I did not know that. That's incredible. But that goes back to what Massachusetts is, and it's, just the start of what makes this Commonwealth such a special place to live and be a part of.
The cradle of liberty.
Yeah.
Yeah.
It really is. So when we talk about separation of powers, we hear that term a lot. What does that mean in Massachusetts, and why is that important?
I'm glad that you asked that question. One of the things that myself and many of my colleagues really love to do is to talk about civics with members of the public, and we couldn't have a broader audience than we do today, but to talk about concepts such as the separation of powers and the rule of law. And to understand the separation of powers, Harry, you need to kind of hark back to 18th century France, when the Baron of Montesquieu came up with this philosophy of the separation of powers. And the separation of powers fundamentally means that there are three co-equal branches of government, such as we have here in Massachusetts and we have nationally. There is the legislative branch of government, the executive branch of government, and the judicial branch of government. They are co-equal branches of government, and as the name suggests, they are separate. So in the legislative branch of government are duly elected officials, debate and consider matters of legislative importance, and they draft up bills, okay, which, when they are approved by the governor, they become statutes. Okay, and that becomes our statutory authority. So the legislative branch of the government drafts up law and also importantly provides for funding for those laws. The executive branch of the government, on the other hand, is in charge of enforcement and the implementation of those laws. And the executive branch of the government comprises the governor's office and locally mayor's office, the attorney general's office, district attorney's office, that sort of thing. And then the judicial branch of government, this separate branch, is charged with interpreting both the constitutional mandates that we have as well as other laws, and importantly, applying those laws to the conflicts that arise in our community. And it's important to have these three separate branches of government because they serve as checks and balances on each other, okay? That is to say that one is a watchdog for the other, okay? And Montesquieu wanted to ensure, and our founders wanted to ensure that no one single branch of government, whether it be the executive branch, the legislative branch, or the judiciary, had absolute power, okay? So that's roughly spoken what the concept of separation of powers and the concept of checks and balances entails.
Is it hard to keep that balance in place? Do we sometimes feel that one department is starting to skew out a little bit or become stronger, or is it hard to maintain that balance in your mind?
I think the judicial response is you betcha. life is complicated.
Yeah, it is.
Okay, and it grows
Right.
more and more complex. And all that is handled at the governmental level, regardless of what branch of government, is enmeshed in what happens in other branches of government. So that, for example, the legislative branch of government may impeach a member of either the executive branch of government or a member of the judicial branch of government. Okay, the executive branch of government can veto a proposed legislation from the legislative branch of government. And the judicial branch of government can find that statutory authority or executive mandates are unconstitutional. So there is constant interplay. And that's what the checks and balances is all about. One of the things that's important to understand that the community has to understand is that facts or evidence are complex. The law is complex. Facts of a case don't always fit neatly into the law,
Right.
which is how eventually law begins to blossom and to grow. Okay?
That's interesting. A little bit off topic, but in your experience, do most countries have a system like ours, or is ours pretty unique in how it works from the standpoint of this separation of powers and the three parts of government?
Well, we like to believe that we have the best system of government in the world in the United States, and here in Massachusetts, we like to believe that we have the best system of government in the United States. But certainly European countries, so-called Western countries, have similar, but I would dare say not as sophisticated, perhaps, systems of
that's my sense.
of governance. But to be clear, our system of government derives from the English system, but with multifold improvements. For example, we don't have a monarchy.
Yeah,
With all due
right.
respect.
Right. Right.
So I think the answer to your question is that there are similar systems. I can say that there are a few countries around the globe which have jury trials.
Okay.
When we greet jurors, we talk about how when they walk into a courtroom, everyone stands for the jury because they are the judges of the facts that are at issue in any particular case.
Right.
And we vest in our citizenry some of the most important decisions. Over the years, I've presided over multitudes of murder trials, wrongful death cases, and the verdicts that have been rendered have not been rendered by me. I would rule on questions of evidence, on legal matters, but that determination is for the members of the public who serve in the jury and the jury alone. And jury trials are at the cornerstone of our democracy. And if you've ever had the pleasure of serving on a jury, you know the awesome power and responsibility that we vest in each other.
Right.
And there are very few, perhaps count them on 4 or 5 fingers, countries around the globe which permit members of the public to determine some of the most important cases that we have. So in that regard, we really shine.
Yeah, no, there's no question about it. So why, in your mind, why is it important to have the courts designed, and I think you've kind of talked about this already, but designed and structured as an independent, co-equal branch of government under the rule of law? And I want to ask you to drill down a little bit on what does rule of law mean? You've kind of referenced that a little bit, but it's a great term, and it really has captured my imagination.
I appreciate that. First, in response to your first question, it's important to have the judiciary as a co-equal branch of the government to preserve the rule of law.
Okay.
Okay, simply put. So, what is the rule of law? That's a term which is often used, but probably pretty poorly understood. The term rule of law doesn't mean rules of law, which candidly is what I thought it meant for a very long time and what most people probably think it means. It doesn't. It means that the law rules. It means that no one, no individual is above the law. And so we have this very interesting system. And when I commented earlier about being driven from an early age to what I now understand as the rule of law, this is what I'm talking about. Back in 1776, when King George III was ruling the colonies, when he was ruling England, he applied the law, as he set it down, to the colonists, to the citizens of England. Okay, it didn't apply to him. Okay, that's because he was above the law.
You're right. You're right.
It was the rule of the king, sometimes referred to as the rule of man. And then it was in 1774 that our very own John Adams, just about 90 miles due east from here, stated that we are a government of laws, not of men. Okay? And that's a term, obviously, that wended its way into the Declaration of Independence in 1776, into the Massachusetts Constitution in 1780, prior to the U.S. Constitution, which was enacted in 1787, in large part fashioned after the Mass Constitution. But that whole concept that we are a government of laws and not of men is the foundation of our democracy, of our government, and the concept of the rule of law. And so under the rule of law, we are all beholden to the law as it is handed down by the legislature, by administrative rulings, for example, and other administrative fiats by the executive branch, and certainly the judiciary. So the rule of law simply means that the law rules our lives, okay? And that no one, no individual is above the law. So that if a state representative, for example, is accused of some malfeasance, of some, say, criminal wrongdoing, that person is not above the rule of law and may be prosecuted. So that's the concept of the rule of law, this concept of justice, that as a judge, we are duty sworn to protect. And when you ask what is the function of our co-equal branch of government, when I say it is to preserve the rule of law, I hope you can now understand how important that concept is. Because it's only through the preservation of the rule of law that we can ensure that we can continue to live in a free democracy.
Right.
So that's what we do on a daily basis.
You know, and again, I'm deviating a little bit from the questions, but when I think about the Constitution and how that was written back then, I look at who those people were that helped kind of craft that amazing piece of paper. We have existed under that Constitution for this long, and it still holds in place. It still has so much relevance, and it's still it's never fallen out of time, so to speak. It's just amazing how insightful they were back then.
Yeah, you know, there's the interesting discussion is whether or not the Constitution should be interpreted strictly, okay, according to what is exactly written, what was written in 1787, okay, or whether or not we are adaptable with it, and whether or not we take principles that are articulated in the Constitution of 1787 and, so to speak, breathe life into it, which is what has inevitably happened, and for good reason, because our lives in 2024 are vastly different. Certainly in terms of technological advances, that sort of thing, than back in 1787. But, you know, the foundational principles of equal justice under the law, of due process under the law, will always survive, because those are fundamental
principles, right?
Yes.
Right. Yeah. Absolutely fascinating. It's just amazing to me, too, that I look back at what they wrote back then and just how it has stood the test of time. And still, it gets tested all the time. But
and let's not forget, the federal Constitution was modeled after the Massachusetts Constitution. Just another plug
Is
for our
that
Commonwealth.
right?
Yes, it certainly was. The Massachusetts Constitution was enacted in 1780, 7 years prior to the federal Constitution, and in large measure based upon the concepts that John Adams and so many others who participated in the drafting of the Massachusetts Constitution put into our founding document. So,
it's amazing what visionaries and how insightful they were back then.
they were really smart.
They were really smart.
Yeah, yeah,
It's incredible.
yeah, yeah.
And to think that, yeah, Massachusetts is really the model that others have looked towards in creating theirs. It's just incredible. You had mentioned earlier that there are 13 superior courts. I learned that one for each county
Correct.
in the Commonwealth. When we look at all of these other courts that exist with probate and family and juvenile, housing, land, you rattle them all off, the appeals court.
Yeah.
Do they exist in all the different counties as well? And are there more than one in each county? Or
Sure.
is there one per county? How is that organized?
Well, let's start perhaps with the largest court, which is the district court, the court where I proudly sat for 6 years. I was assigned to the Springfield District Court, which was the busiest district court, without too much surprise in the Commonwealth. I mentioned that its companion court is the Boston Municipal Court because they have the same jurisdiction, which we could talk about. Basically, they handle the same sort of cases, but the BMC, as we call it, as its name would denote, is in Boston. There are 62 district courts. The Boston Municipal Court, gosh, I think there may be 8 separate divisions of the BMC.
Oh, wow.
But don't hold me quite to that.
Yeah, that's okay.
There are probably about 180 or so district court judges throughout the Commonwealth, including right down the block here in Westfield District Court.
Right.
Okay. Special shout out to my good friend, the presiding justice, Charles Gross, and also to Justice John Graney,
Yes.
who is Westfield's very own, who initially served as the Housing Court Justice, then on to the Appeals Court, where he was chief, then on to the Supreme Judicial Court.
Yeah, a great friend to our city.
So, indeed. And so, moving to the next court would be the Probate and Family Court. And just as the Superior Court has a court in every county seat, so too does the Probate and Family Court. And we could talk a little later on, if you wish, about what these courts do. The same with the Juvenile Court, although they have the Juvenile Court has courts in each of the county seats and additional satellite courts. For example, here in Western Massachusetts, the Juvenile Court sits in Springfield, in Holyoke, in Hadley, as well as in Greenfield. Okay. Then we have the Land Court, which is a very interesting court. That's a court that only sits in Boston and sometimes travels out to other parts of the Commonwealth, but principally serves in Boston. And there's only one land court. The land court has a grand total of, I think, of 7 judges. So that's the district court, the Superior Court, Probate and Family Court, the Juvenile Court, the Housing Court, and the Land Court. Okay.
And you had mentioned earlier that they all have prime functions. Can you encapsulate quickly?
Sure,
just what
sure, yeah. So the district court handles a very wide variety of cases. We like to refer to the district court as the gateway to justice. That is to say that the overwhelming majority of cases start off in the district court. That is the case where if there is an arrest or a summons into the district court, and individuals are arraigned on the criminal side, and criminal cases in the district court involve cases which are all misdemeanors and felonies that are punishable up to 5 years in state prison and some other designated felonies. But quite importantly, in the district court, The judge is only authorized to sentence an individual up to 2.5 years in the House of Corrections. That's the maximum sentence that a district court judge can hand
really?
down. A district court judge cannot sentence an individual to state prison. The district court also importantly handles a very large number of abuse prevention orders, sometimes referred to as restraining orders, harassment protection orders, which are matters that might arise between neighbors as opposed to individuals who are domestic partners or somehow related. The district court does yeoman's work in handling a number of mental health cases, that is to say, commitments based upon mental health issues, as well as commitments based upon substance abuse disorder. And here in Hampden County, we have an exceptionally large number of cases that present in those particular sessions. The district court on the civil side handles all civil cases in which the amount in controversy is under $50,000. People are probably very familiar with the small claims court. That's for cases that are up to $7,000, and a fast way to get some adjudication on a case involving less money. The district court also handles landlord-tenant cases. The district court is an exceptionally busy court. I would handle 100, 120 conferences in one day in the Springfield District Court.
In a day?
Yes. So in actually less than a day. It's a high volume experience, which makes it very, very different from the Superior Court.
Right.
In the Superior Court, we handle generally felony offenses, which are punishable up to life in imprisonment without the right to parole for a conviction on murder in the first degree. Handle all manner of serious felonies, a large number of drug cases, including drug trafficking cases, sexual assaults, kidnapping, some very, very serious criminal matters. And on the civil side, we handle cases that have a value in excess of $50,000. I took in a jury verdict for over $30 million on a wrongful death case on one particular case. So in general, in the Superior Court, the cases which present are quite complex, both on their facts as well as on the law. And the pace in the Superior Court is proportionately more measured and pensive, so to speak, than in the district court. And I'm not suggesting at all that there is more thinking going on in the Superior Court at all. The cases involve a higher degree of analysis simply by virtue of their complex factual and legal components. On the other hand, the number of decisions that a district court judge has to make during the course of her day exceeds the decisions of a Superior Court judge probably 100-fold.
Wow.
So they're different skill sets.
Right.
Okay. In the probate and family court, as the name would suggest, the judges handle both family law matters such as divorce, unmarried couple issues such as support for unmarried couples, all matters pertaining to child custody. They also handle abuse prevention orders, as does the district court. And on the probate side, they handle estate matters. So let's say, for example, there is a will contest. Someone suggests that an individual was unduly influenced in drafting and signing off on a will. They handle will contests in that court as well. They also handle adoptions. And that's similar to the juvenile court, which handles all matters involving children, including adoptions, care and protection proceedings, children in need of services proceedings. They also handle delinquency proceedings for individuals. I believe the bottom age is 12 up to age 18. And so that is the juvenile court. The housing court handles residential housing matters, and that can range from the bulk of those cases, which are eviction cases, to construction defect cases. Someone builds a house and there's a construction defect. Arguably, you can have that heard in the housing court just as you could have it heard in the district court or the superior court. And the land court, as I said earlier, deals with issues that pertain to land. So that, for example, I just mediated a case yesterday that was pending in the land court, and it was a petition to partition land. Two individuals owned land together, and they wanted to force the sale of the property and the distribution of the proceeds. And so all those courts, all those trial courts, then have a right to individuals who are litigating in those courts have a right to appeal to the appeals court.
Okay, so everything feeds up to the appeals.
To the appeals court, which sits in Boston. There is a satellite office here in Springfield, and an appeal can actually either go directly to the SJC, or ordinarily the appeal will go from the appeals court up to the SJC, and they are the final arbiter of law in Massachusetts. And they are the only authority which arguably can make new law. Okay, a trial judge such as myself, pardon me, is beholden to the law, whether you agree with it or not, as it is written, and to apply the law to the facts of the case. And that oftentimes makes judges very unpopular. But the fact of the matter is that judges apply the law as it is handed down through legislative mandate or statutory mandate, that is to say, whether it's through governmental regulations, through the executive branch of the government, or through our own common law.
So the skill sets for each of those different courts has got to be really complex, because there's so many different rules and guidelines that you have to follow and be aware of and understand in order to rule properly. And, you know, you said something that was curious to me. Regardless of whether you believe in it or not, is that what you were saying? You still have to follow the rule of law.
Right. Let me give you an example. I had a case. This case is long beyond its appellate period, so I can talk about it. It was a case I was construing a city ordinance for a municipality here out west relative to needle exchange program. And the manner in which the ordinance had been approved was at issue, okay? And while I personally might believe that needle exchange is a good thing, okay, the manner in which this ordinance was processed and the ordinance itself dictated otherwise. And a strict reading of that ordinance, and so an ordinance is law. Now, this is a measure of law that comes from the executive branch of the government, it came through a municipality, okay? While I personally may not have agreed with the ordinance, I had to apply the facts of the case as I found them to be, and the facts were uncontested in this case, right, to that ordinance. And the result was a horrible result. The result was that this needle exchange program was unlawfully approved. So, what's a judge to do?
Yeah, right.
What I did was I issued my order, and this wasn't a trial, it was on motion hearing. I issued my order, and I gave the parties 120 days to straighten the mess out. And they did.
Wow.
In 120 days, the governor, who I believe was then Governor Baker, propose new legislation to cure the defects in the existing
Oh, that's
legislation,
interesting. Wow.
to correct it, put it in place. Then a motion came back to me to reconsider, saying, okay, now the law is different, and that cured the problem. So that's a really good example of how when we are directed to follow the law, there are different ways to proceed with that, but one way is to stay enforcement in order and give the legislature, the executive branch of the legislature, an opportunity to correct it. And that's in an instance where the ordinance itself was, pretty black and white. It wasn't and subject to interpretation. So that's one example of how the law can grow.
Is it hard, or is it a big challenge for judges to really separate your personal feelings and from influencing the rulings that you have to make based on law, based on fact? Do they ever get clouded, or are you able to really keep a clean separation?
Yeah. Well, let me just give you a news flash. Judges are people.
Yeah. Right.
Okay.
Exactly.
But we are beholden to a code of judicial ethics that keeps us accountable, that vests a degree of confidence in the judiciary that the public needs. And the cornerstone of our code of judicial conduct are what we call the 3 I's: independence, integrity, and impartiality. So that last one goes to your question. We have to apply the law to the evidence as we find it to be, the so-called facts, regardless of what our personal sentiment is. And many have been a day when I have simply put aside whatever personal feelings I may have had as to a case in order to quite clinically apply the facts of the case as they have been proven to be to the law. The other 2 I's are independence, okay? And it's important to understand that in Massachusetts, we are appointed by the governor with the advice and consent of the Governor's Council, and as suggested by the Judicial Nominating Commission, up to age 70. Okay, that gives us a lot of independence. That's because I don't need to run for office every couple of years or worry about a recall, and then find myself looking at a campaign donor at the other end of the courtroom. And so, and the other I relates to integrity. Okay, and that
I
is
like that word.
And that is to say that we truly, as individuals, public-facing, need to promote confidence and integrity in the judiciary. So, the ability to judge impartially is something that is a skill that has to be demonstrated on day one, but one that needs to be learned.
You referenced the term promote confidence.
Right.
I love that term.
Yes. Yeah.
And that really is what it's all about. People
Absolutely.
have to have confidence.
I had a mentor, Judge Nancy Ducek Gomez, back in the Springfield District Court. I'll never forget, I was, back in the day, I was very active in the Bar Association. I was president of the statewide Bar Association, the Mass Bar Association, and we were out doing civics and education outreach. And Judge Ducek Gomez and I were speaking at a school in Springfield. And she stood up in front of the classroom as an opener and put her arms to her side and said, "I am justice." And the kids were looking around thinking, okay. And what she meant was that her title was Justice. My title was Justice, Justice Mark Mason, okay? I am the face of justice, okay? The administrator of justice. I represent the rule of law. And when we talk about promoting confidence in the judiciary, what we're all about is promoting the rule of law. That's what it's all about. It's not so much about me, Mark Mason. When I would go home and take off my black robe, my family truly could care less who I am and wants to know where dinner is. But when a judge puts on that robe which represents the rule of law, we are there to administer the rule of law in the community.
Yeah, that's a great, and that's a huge weight. That's a huge responsibility.
Yeah.
To ensure.
Yes, it is.
It's a huge responsibility.
It is a huge and tremendously important responsibility.
Right.
And what's interesting, Harry, is that I was, a judge up until very recently for a period of 15 years, and it's a wonderful, wonderful opportunity to do good. Okay, but we handle some really horrible cases.
Yeah.
Some really difficult cases. Imagine looking at photos of murder victims. Imagine addressing the families of victims of severe violence at sentencing and trying to keep a dry eye. There is stress in what judges do, as well as what members of our courtroom family do, our court officers and clerks and probation officers. But as with any profession, we learn to deal with it, okay? But it's there someplace. It might be subliminal. It might be secondary. And, there's all sorts of important movements to ensure that not just judges, but the lawyers who represent individuals before our courts take care of their well-being, because it is a very stressful job. And because we do a high volume, after a period of time, I won't say that we become immune to it, but we may not be taking full cognizance of the level of stress that we endure.
Yeah, my hat is off to you, I will say. That's an amazing level of responsibility. So the Superior Court, how do the cases get to you? What's referred up?
Sure.
Are cases ever refused?
Okay. All right. No case is ever refused. Say that when a individual comes to the clerk's office on the civil side, let's say, and wants to file a case, the clerk's office cannot refuse a case. I suppose if the case is in improper format, let's say an individual represents themselves and they want to file a civil complaint and they just have a letter, okay, they can be instructed to meet with a member of our court service staff who will assist them in writing the word complaint on it, okay? So sometimes things that are just patently unrecognizable or incorrect can be returned to the person who's filing just so that they can refine it. But no civil matter can be turned down by the clerk's office. And sometimes we get matters filed by self-represented litigants, which are very difficult to decipher and understand. And it's our job then to, if we have a hearing, to work with that individual to develop an understanding as to what it is. And that's because everyone who comes to court, whether or not they're represented by counsel, is entitled to the same level of due process and equal protection under the law.
Okay.
So on the criminal side, it's different. I mean, those cases either come by way of an arrest, okay, at which point someone is brought in by the police and is arraigned, or they're brought in by way of a application for a criminal complaint in the district court or the Boston Municipal Court. And there is some discretion, because what happens there is that if the police don't witness a crime, say that someone alleges that his neighbor hit him and is alleging assault and battery, okay? That person can file an application for a criminal complaint with the Westfield District Court, and a clerk will bring the parties before the court and conduct what's called a show cause hearing, okay? And the applicant, the named victim, has to say that there is a good reason for this complaint to be processed in the court. And at that hearing, the defendant has an opportunity to be heard if they wish to be heard. The clerk may not issue that complaint. The clerk may deny the issuance of that complaint if the clerk doesn't find that there is sufficient cause to issue it. So technically, on the criminal side, not all cases that are filed end up in court.
Interesting.
Yeah, you're still awake. You're doing great. This is hard stuff. It's pretty boring.
No, it's fascinating because it's so many. What I was thinking about is there's so many levels of complexity to it.
It's extremely complex, and I think that the frustration that many judges have is in the public perception of what it is that we do, because the public perception, aptly so, is born of media reports.
Right.
Okay, and the media report it's just a headline.
Right.
You know, you can have a hearing that went on for a month and a half,
right,
and you'll get a one-paragraph summary, which may not be entirely correct to the extent that it doesn't fully disclose everything. And certainly, the public oftentimes doesn't understand the complexities of the law that we deal with.
Did you have a preference over civil law, civil cases versus criminal cases, or was it pretty much equal to the kinds of things you were dealing with?
Yeah, that's a great question. You know, I really enjoyed the balance, and in the Superior Court, we were careful to ensure that cases were assigned equally. Roughly a third of the cases that I would hear are civil, which is probably about proportionate to the number of filings. So I'd spend, probably 4 months or so a year doing civil work and the balance doing criminal work. But it's important to get a break from one from the other. On the civil side in the Superior Court, there is a lot of writing to do. And if you're someone like me who really loves to write, it's a great job. And so I would say that the hours tend to be, can be a bit longer sometimes on the civil side. On both the criminal and civil side, in the Superior Court as compared to the District Court, we see a lot of trials, a lot of lengthier trials than we see in the District Court. And that takes up a lot of our time. But whether or not they were civil or criminal matters, at the beginning and the end of the day, Harry, we are dealing with members of the public. If you're in court, you're not having a good day, okay?
Yeah, right.
Think of how many times you've been in court other than perhaps going in as a juror. You're facing some of the most difficult conflicts in your life. And we are there to ensure that everyone, all members of the public are treated, and counsel are treated fairly and equally. And I loved that process. There is nothing like conducting a jury trial and seeing democracy in action. So whether it was a criminal trial or a civil trial, the process is one which, from my perspective as a judge who was doing my work as a job, so to speak, was just an absolute blessing. So, whether or not it was criminal or civil, it was all a gift as far as I was concerned, personally.
As you look back on your career, District Court versus Superior Court, I'm sure you have fond memories of each. Did you have a preference as you look back to one experience over the other, or was it just the natural ascension of career moving up into more influential positions?
Yeah, and I don't like to look at it in terms of influence, because at the end of the day, the reason I do what I continue to do, continue to do now in my mediation practice and all the work I do with civics and education, the reason why I do it is because I love giving back to the community. And so, I was president of the Statewide Bar Association, and every time I looked in the newspaper, I saw my face, and if I had seen my face in print one more time, I was just going to jump. I don't I don't look at these things in terms of influence. The case that is tried before the district court, which is the first time operating under the influence of intoxicating liquor, is oftentimes as important to that individual as a much more severe a crime with a much more severe penalty in the Superior Court. That's because we're dealing with people, okay? And so my focus, and I do believe that the focus of most of my colleagues is on the members of the public as opposed to their own ego. But in evading your question purposefully, it's all good. The district court experience was wonderfully collegial. Just some of the brightest, most dedicated, and funniest group of people I'd ever had the pleasure of working with. And in the Superior Court, it's a slower pace to the extent that it's a heck of a lot more pensive. It's more insular than the district court was, and that's because everyone tends to be in their own silo, very busy, hard at work. So there are different courts, there are different cultures, and they each offer their own benefits.
I found in life that as I look back at my career, that every job I had was the best job I could have ever had at that point.
At that, you got it perfectly.
It was always the
perfectly
best job.
stated.
I always looked at it, I looked back and I said, that was the best job I could have ever had at that moment in time. And they just kept getting better and better. But every job I had was always the best job I could have ever had.
I agree.
I just always loved them.
The decision for me to retire early, 5 years earlier than I had to, was bar none the most difficult decision of my life.
I'm sure.
But the time had come to turn back to some of my roots. Doing mediations, the work that I had done back in 1988.
Right.
And so as difficult it was to leave the court after 15 years and leave the practice of law as I had for 24 years, it was time to turn the page to the next chapter.
Mm-hmm. Yeah, absolutely. Yeah, fascinating. The daily life of either a district court judge or a superior court judge, people think, well, they're just coming out, they're sitting at a bench and they've got a gavel and they rule. I'm guessing that there's a tremendous amount of research, reading, studying, and trying to understand the complexities of the course within which to properly render decisions.
Absolutely.
Can you go into that a little bit?
Sure. And it's fair to say that I think most judges, including myself, over the course of 15 years, build up a battery of memoranda of decisions so that we are familiar with the law and can draw upon those prior drafts as we move forward with cases, so that we're not reinventing the wheel every time we hear a case. But I would say that perhaps maybe 40% of the time that a judge spends is on the bench, if not less, maybe a third, okay? The rest of the time is spent reading through the parties' briefs, researching the issues, and writing, okay? In the Superior Court, there is a heck of a lot of writing, and writing which is done at a very scholarly level. And so it's a lot of work. And, just as with attorneys, and other professions, you take it home with you.
Right.
Okay, so just because I'm not at my on the bench or in my office doesn't mean that I'm not thinking about the law and adjudication on certain cases. These are really weighty decisions, and as much as anything, we want to get it right. And so it's an all-encompassing job. It's a lifestyle.
Yeah, no, I can understand that. I want to talk about your new work, mediation, arbitration.
Great.
What is that? Why is that important?
Sure.
And who should be accessing that service that you have?
Great, thank you. Well, It was back in 1985 when I first started practicing law in Holyoke and Springfield that I first became acquainted with a mediator. And my thoughts were, what's a mediator? And I learned what mediation is. And I thought, wow, that sounds interesting and redeeming. In a mediation, a mediator, such as myself now, and there are many mediators in the community in Western Mass, works with parties in a civil case, whether it be a sort of cases I handled as a Superior Court judge, a breach of contract case, or a personal injury case, or oftentimes in a family law case, such as a divorce. Mm-hmm. A mediator works with the parties to explore their interests, to understand, help them in understanding the strengths and weaknesses of not just their own case, but the other side's case, in coming to a reckoning with the cost associated with litigation, the risk associated with litigation, indeed the uncertainty associated with litigation, and assists them in negotiating a resolution to their case. Mm-hmm. The reason why mediation is so valuable is that it helps the parties take control of the resolution of their case. You know, I can count on many hands the number of cases in which I sat as a judge. For example, an individual is involved with a rear-end collision. She is, stopped at a red light, on a summer day, okay, on her way to church, okay, boom, rear-ended, okay. Case, and she is significantly injured. Case goes to trial, defense verdict, okay. That's not a good thing in my mind. That is to say that there is risk associated with trial. There's always risk associated with trial. There's risk associated with how a judge is going to rule on a motion. That is to say that when you go to court, you do not have complete control, okay? In a mediation, you take control of your case.
That's interesting.
In a manner that makes you responsible for your the resolution of the case. And even if it is not what in your world of worlds you had hoped to achieve in the case, you are able to look back and say, I agreed upon that decision, and in doing so, that settlement, and in doing so, I eliminated the cost, the time, the risk, and importantly, the stress associated with litigation. Now, the sort of cases that I currently handle are civil cases. But as I said, mediation applies to pretty much every department of the court that we talked about. Okay, and we don't utilize it in criminal matters. That could be a different discussion, I guess. But for our intents and purposes, we do them in civil cases. So if you have a landlord-tenant case, if you have an employment discrimination case, if you have a breach of contract case, business partners are involved in a dispute. Someone's involved in a slip and fall or a medical malpractice or legal malpractice, wrongful death action. In the probate and family court, if there is an estate contest, if there is a divorce. All of those cases are cases in which parties can and should consider taking control of the resolution of their case in a manner which they control. And a mediator is skilled in assisting them doing so. And in particular, I think it's important to have a mediator who has been observant of what judges and juries can and have done. Because in any negotiation, Harry, we're always negotiating against what we call our best alternative to a negotiated agreement, meaning if I don't settle, what's going to happen? Well, if I don't settle, I'm going to go to trial, okay? It's helpful to have an understanding as to what the parameters of that risk are, so that you can then gauge, okay, do I want to spend $10,000 on an attorney if I'm only going to get $8,000 back. Okay, and at the end of the day, in many mediations, we're talking about money.
Yeah, right.
And we're asking the parties to make a sound business decision, which effectively is a cost-benefit analysis. So that's the sort of work that I started doing back in 1988 after I had met this mediator, and I thought, well, that's a redeeming, wonderfully progressive way to look at the law. Trials are a wonderful thing, but not every case needs to go to trial. Okay? There are cases that need to go to trial. We need to build common law. We need to have cases tried and have them appealed to build our case law. But not every case is that case. And members of the public, and in particular the business community, in 2024 look to, as we call it, alternative dispute resolution, rather than a very costly and timely and risky litigation in our courts. And that's why mediation has become so popular. I also do arbitration, which effectively I like to say is like a trial with coffee. That is to say, it's a trial, it's an arbitration at a conference table, and the arbitrator, either a single arbitrator such as myself or a tribunal, will sit and hear the facts of the case and render a decision just as a judge would do so. There, too, the whole idea is to do so in a manner which is somewhat more informal than court, and to provide some cost savings for the litigants.
In that kind of case, do people consider your ruling to be, that's it, we must abide by it?
Yes. So most arbitrations are a result of a contractual provision in, let's say, it's a purchase and sale agreement. Okay, you go to buy a house, and let's say that the seller reneges on the agreement. You're going to sue. There's a clause in that, okay, clause 15, that says that any dispute arising from this purchase and sale agreement will be subject to binding arbitration. Okay. That's your contract.
Okay.
Now, sometimes there isn't a pre-existing arbitration clause, and so instead the parties say, okay, we want to submit this case for arbitration to Judge Mason. They then enter into a binding arbitration contract. I've never seen anyone enter into non-binding arbitration. They may wish to come to someone for a case evaluation, which is non-binding, but if you're going to go through all the effort of presenting your case in a manner such as a trial, then generally spoken, you're going to want a binding decision from the arbitrator.
It's not a case, well, I'm going to go, and if it rules in my favor, we'll go with it. And if it doesn't, well, we'll just walk it away.
Who would do that? You know,
Right.
Arbitration is also expensive. Mediation tends to be much more casual. There's no presentation of evidence in a mediation.
Right.
The mediation is the parties, their counsel, if they have counsel, and the mediator. And what's important to understand is that mediations are confidential, and arbitrations too can be confidential. There are many cases, for example, employment discrimination cases, where the parties want to keep both the litigation as well as the resolution of their case quiet. They want to keep it confidential. Mm-hmm. Everything that happens in a court of law is public information. And so a lot of cases are brought to mediation exclusively for that reason. And so, there are, it's interesting to have seen the surgence in the mediator population in Massachusetts. I think it's a really good thing. When we look back at Star Trek episodes to get a sense as to where we are going in the future, they didn't have, with all due respect, a ship lawyer or a ship judge. They had a ship mediator.
Right.
So
yeah,
it's the way of the future.
Yeah. Well, this has been an absolute, we're actually over an hour now, and it's been fascinating.
Time flies.
It does fly.
Yeah.
You know, Judge Mason, our guest today with Westfield Council on Aging, presents A View from the Bench. I commend you on an outstanding career. And what I'm most impressed with is your respect for the law and the important responsibility that you internally accept for ensuring the integrity of law and to make sure that it is ruled on fairly and that everybody has their opportunity regardless of who they are and where they come from. And that's just incredible. A couple of the things that really stood out for me, preserving the rule of law. I just love that term. No one's above the law. We hear that on television a lot right now. There's a lot of stuff going on around that concept. But really promoting confidence in the judiciary, that the work is going to be done, the cases are going to be heard, and it's going to be fairly decided on as best as can be. So, well,
you're too kind, Harry. The pleasure has been all mine. And on behalf of the Massachusetts Trial Courts Public Outreach Committee, thank you to the Westfield Council on the Aging. As I say, the pleasure has been all ours. Thanks for giving us this important opportunity.
Well, we thank you. So thanks to my guest, the Honorable Mark Mason, speaking on the Massachusetts court system and the Superior Court, where he served as an Associate Justice for 9 years and a phenomenal career. Special thanks to Pete Coles, our WCPC Westfield Cable Channel 15 manager and producer, for his help to make the show possible. And on behalf of Pete Coles, Mike Squindo, and Tina Gorman, I am Harry Rock. Thanks for tuning in to another edition of the Westfield Council on Aging Presents. We'll see you at the next show. Thanks.
Thank you.